The High Court in Durban, that's where we're expecting closing arguments in the bail application of 5 men who've been arrested for killing AKA and TIBZ. Watching those developments for us is Vusi Khumalo, who's live to us now from the courtroom itself. And I suppose, Vusi, before we speak about what to expect today, get us a sense of what's being said so far in this bail application.
Yes, good morning, Ayanda. Yes, indeed, you may recall that since AKA alongside his friend TIBZ Motsoane were gunned down in Durban, Florida Road last year, there's been a lot of noise, especially in Durban, with regards to the arrest. Well, eventually there were people who were arrested. 5 of them, the accused, are appearing today, with 2 of them remaining in the country, in the neighboring country, Eswatini, and they are yet to be extradited back to South Africa to face their music here in the country of South Africa. Well, this case so far, this is currently the bail hearing. Today we are expecting the closing arguments. You may recall that the accused have always maintained their innocence, wanting to be granted bail, saying that they were not, the state's case is weak, and that if they do get bail, they will not evade trial. But we're going to hear that from the magistrate Vincent Hlachwaya today as to whether he does or not give them bail as it is wanted by the accused, with their lawyers having presented very strong cases as well, but the state is also saying that it has got a very strong and tight case, saying that the accused, all of them, were arrested in different places, with some of them still not here in the country. But you're going to hear more of that, especially from our legal analyst, our legal expert, Abigail Ngobene, who's going to take us through about just perhaps the background so far. Maybe just before the background, if you can just tell us and explain to us about whether the accused, whether the interest of justice does permit them to be granted bail, because we are today it's the closing remarks from the judge, from the magistrate.
Look, it's a complex one. The applicants have made the application. Of course, the state have rebutted that. And a lot of factors which the state, of course, ventilated to say in terms of Section 60, subsection 4 of the Criminal Procedure Act, there are factors that, in their view, they feel that the interest of justice don't permit their release on bail. But, of course, the applicants came back to respond to that through their affidavit and poked some holes in trying to show the court that the state's case is actually weak, which, of course, if it's taken to a trial court, they are likely to be acquitted or discharged. So one cannot say whether the interests of justice do permit their release on bail. It will depend on their arguments which are going to be delivered today. Both sides are going to come with case laws. They are going to come with a certain piece of legislation to try and show the court that, in fact, their interest of justice, the interests of justice permit their release on bail, and they have exceptional circumstances which needs to be balanced with the two. But the state, of course, will come and rebut that.
And also considering the fact that all of them were arrested in different places here in South Africa, and some of them are still in the country, in Eswatini, how will that be factored in by the magistrate when he makes his final remarks?
Remember that the main thing, as part of the main legislation which regulates a bail application, is whether or not there is an availability of any of the factors listed in subsection 4, as I alluded before. Part of those will be to show the court whether they will evade trial, and that speaks to how they were arrested. Remember that Gwaben, who is termed and a mastermind, handed himself in, and that may also play a positive role in a side to say, in time of arrest, when the police were looking for him, he handed himself over. But of course, that is not the only issue. Remember that this is termed or is categorized as a premeditated, coordinated kind of an offense, which of course will have to come and be determined on whether or not they will not jeopardize the functioning of the criminal justice system should they be released on bail.
And also another factor to ponder is the fact that most of them have got previous convictions and also pending matters.
Yes, that is one of the things. Remember that part of the things that the state had to come and say to the court and say the interests of justice don't allow their release on bail was the fact that others are connected to other offences which are similar to this one. And the strategy that was used by the police was that of a parallel strategy where they link them to other cases. And many of those cases, we are told, are cases similar to this. And this court will take that into consideration to say if they are released on bail, are they not likely to commit what we call a Schedule 1 offence? Because that as well can work against them. The fact that they are linked on other cases, the fact that they have pending cases may highly impact their application. But of course, number 4, who is termed the mastermind, we are told he doesn't have a pending case, he doesn't have a previous conviction, but still the onus will be on him to come and say, have he satisfied the requirements of somebody who needs to be admitted to a bail?
Thanks a lot.
Thank you very much. I appreciate it.
Thanks. Well, Ayanda, as we've heard, our legal analyst here, Abigail Ngobeni, just exploring all the ways upon which the magistrate today, Vincent Hlatshwayo, will have to navigate through and also determine whether the accused, 5 of the accused, will be getting bail or not. Ayanda.
Absolutely. Was not lost on us, of course, is that there are 2 other men who've been arrested in connection with this crime, waiting for the extradition application to wrap up in Eswatini. So a number of moving parts. For now, Vusi Khumalo, live to us from the High Court in Durban.